All right, this was a fun one to break down. As a Patriots fan that lives here in Boston, we're going to talk about the lawsuit between Julian Edelman of the New England Patriots and his longtime friend and business collaborator, and a deal that went wrong, right? It's simply the latest high-profile reminder that informal business arrangements, particularly those involving equity ownership or profit sharing, tend to unravel at the exact moment that they become valuable. So a company that began as a conversation during a haircut grew into a company called Super Digital. It's an influencer marketing firm reportedly sold for $50 million. According to Edelman's complaint, he was described as a partner and he helped generate deals and contributed to the company's growth. When the liquidity event arrived, he allegedly received nothing. And so obviously wasn't the proper documentation in place memorializing that deal. And the emotional core of this dispute, is obvious. The legal failure beneath it is what's instructive though, and what I want to talk about. In Gesmer Updegrove, we represent tons and tons of startups, right? These ventures are built typically among friends. There's a tendency though to substitute documentation, especially early on, with trust. I know this person, right? Words like partner, we're building this together, we'll figure it out later. That carries a ton of weight, especially socially among people you've grown up with or you've known for a long time, but they're dangerously imprecise legally. And securities law doesn't recognize friendships. It recognizes defined ownership interests, contractual rights, documented expectations. You don't get a cut because you're my buddy, or you can prove that you were my buddy, right? And so if Edelman's allegations are taken at face value, the dispute likely turns on a familiar set of questions. One, was there an enforceable agreement granting him equity, right? Is it written down? Was it verbal? If it's verbal, can we show a kind of history of behavior that kind of supports a theory of a verbal agreement? Did his contributions constitute consideration sufficient to support an ownership interest, right? In terms of things he did to help the company succeed? Were there any securities issued, promised to him, implied to him, right? Can he establish essentially a partnership status under state law, right? These aren't like, philosophical questions, right? These are like evidentiary based questions, right? And so without documentation and evidence to support this, it becomes pretty difficult and uncertain to answer some of those questions. One of the most overlooked realities in these kinds of situations, right? We have these conversations every day. Anyone who represents startups, right, deals with these conversations all the time. Under federal law, a security includes stock, investment contracts, and in many cases, informal arrangements, right? Where one party contributes value with the expectation of profits derived from the efforts of others. That definition is deliberately broad. It's designed to capture exactly the kind of arrangement that often arises between founders, advisors, and early contributors to a business. And so when one party fails to formalize these arrangements, a lot of different risks emerge, right? One is just the ambiguity surrounding ownership. Without a clear cap table, you're a millionaire, you're a professional athlete, you would assume that would be documented properly, but it's super unclear who owns what without documenting stuff, right? The other is like regulatory exposure, right? So improper undocumented issuances of equity conversation over a phone call creates compliance issues, right? There's disputes surrounding liquidity events all the time, right? And so if you don't have clarity, right, when money's on the table, you're just asking for a fight, right? The legal system will eventually enforce precision onto an arrangement, even if it didn't begin without it. And if you didn't prescribe the details, it's a pretty risky situation to be relying on the court to impose them, right? So a recurring theme in these kinds of disputes is the sweat equity idea, right? The idea that contributions of effort, relationships, brand value entitle someone to ownership. And that concept is valid as an idea. It's also one of the most litigated areas in closely held businesses, right? Everybody who's added value to something, once people start getting paid and breaking bread, you look at what other people got, look what you got, and you're like, hey, does this compute to the value that I put into this business, right? And so whether there was a meeting of the minds regarding ownership or not, that's something that if contested, you might not be in the best position to fight against, right? So I think another question is, whether compensation was expected, right, to be equity versus payment for services. Did this person receive cash? What did they receive for doing this stuff, right? If they're constantly doing all these things for the business and they're considered a partner, but they don't get any money, then, that looks like some sort of partnership type of arrangement. But it's a fragile foundation to, tie that to a claim to a multi-million-dollar exit, right? And you should never rely on it. And, this isn't a plug, right? But counsel is not optional, right? It's not optional. You're starting a business. There's this persistent misconception that legal counsel is something that you bring in later. Once the business has traction, once the business has capital, once the business matures, we'll bring in legal counsel. Then we'll figure this stuff out. But in reality, the most critical legal work happens at formation. It happens right away during the earliest stages of collaboration. And so competent securities and corporate counsel would have, at minimum, addressed the equity allocation, who owns what, and on what terms. We would have addressed vesting and performance conditions. In other words, what must be done to earn that ownership, and what triggering events happen that you actually get those shares. We would also document the contributions of different partners and parties to the transaction, to the company, whether those services, introductions to people, branding efforts, whether that translates into equity. We would also look at compliance with the securities laws. That's my wheelhouse first and foremost, ensuring that any issuance of equity complies with federal and state requirements. We would also think about exit rights. What happens when there's a lot of money at the table? What happens when there's a sale or a merger or some kind of liquidity event, right? These are the core foundations of what a company is. This is the architecture of the relationship that forms a company, right? A company is run by human beings. It's a legal entity, it's a black box, but I think the real cost in this situation isn't the lawsuit, not to be corny. I don't think it's the litigation itself, although the litigation will be expensive and it'll be public, and it's embarrassing, I'm sure, for Edelman, based on his status in the community, to have not, figured this out in the right way. But I think the greater cost in these kinds of situations is the relationship, right? Disputes like this almost always involve people who, at one point in time, trusted each other. They trusted each other enough to start something that could potentially be big without guardrails. They did it based on trust. And by the time the legal system becomes involved, the business may already be successful, but the underlying relationship is probably beyond repair at this point, right? And so the law, in this sense, doesn't create the conflict, right? But it exposes the absence of a structure that allowed the conflict to grow unchecked. And, I think a simple principle that you can take with you that I think is routinely ignored, right, is one simple thing. If ownership, compensation, or profit sharing is part of a conversation, you're talking about building a company that you're going to share, it has to be documented. That documentation does not signal distrust. It does not. That's BS. It preserves alignment. It ensures that when success arrives, that the outcome reflects what your expectations were. That's all you ever want to do. That's what lawyers are trying to do. Preserve the expectations. What did we all expect? What did we all get into? We all shook hands, right? You shook hands, right? But what does that mean when we shook hands? Let's make sure we're all on the same page so that this doesn't become a mess later. If you have a startup, if you figured this stuff out, if you thought about it, if you've got halfway there, you want to talk about any of this, reach out to me or someone on my team at Gesmer Updegrove. My name is Braeden Anderson. Thanks for watching. As always, see you next time.